Good afternoon, everyone. This is Ray Pascucci. Thank you for attending this webinar. I have been handling NLRB elections, hundreds of them over the past almost 30 years. I did a webinar on this same subject back in February. For those of you who listened, this is going to be very similar. The rules are the same as the ones that were threatened back then. The difference is now it's not an idle threat. Now the rules are actually voted upon by the NLRB and will become effective. So let's get started. Okay, very briefly, the National Labor Relations Act is a federal statute. It covers all private sector workplaces. It gives employees the right to unionize. Employees have a choice either to be union or to be non-union. The law is supposed to be neutral. The National Labor Relations Board is a federal agency that was created to administer the law. The NLRB is supposed to be neutral. The reason I say supposed to be, as many of you I'm sure know, is that this is a very politicized agency, probably the most politicized agency in government. And it tends to swing with the winds that are blowing in Washington. There is institutional bias at the NLRB. First of all, the agency wouldn't exist without organized labor. Secondly, it tends to attract pro-labor, ideologically minded individuals. And third, the agency personnel, the board agents who investigate unfair labor practice charges and who process representation petitions all belong to their own internal union, which gives them that particular perspective on their own workplace, I'm sure, as well as all others. The biggest reason that the agency is so politicized, though, is that it is headed up by a 5-member panel that sits in Washington, D.C., and these 5 individuals are appointed by the President, but they're subject to confirmation by the Senate. The long-standing tradition in Washington has been, because the Senate is sometimes ruled by party other than the President's party, has been to split the 5 seats into 3 who are considered selections from the President's party and 2 who are considered selections from the opposite party, the opposing party. So today we have Mark Pierce, who happens to be from Buffalo. Many of you may know Mark. I know him personally very well. He was a union side attorney for 20 or 30 years before he became a member of the NLRB. Nancy Schiffler and Kent Hirazawa, are all those 3 are considered to be Democrat Party selections. And then we have 2 Republican Party selections, Miscamara and Johnson. So what happens, just like with the U.S. Supreme Court, depending on the composition of the court, but lately you get a lot of 5-4 decisions there. Here you get a lot of 3-2 decisions. And that's nothing new. The history of the NLRB, if you go back to I guess when I started, it was the Reagan administration, and that was a pretty pro-business NLRB. And then it shifted under Clinton, and then it shifted back on, before Reagan, of course. When I first began practicing, we were still dealing with a lot of Carter board decisions. So Carter was pro-labor, of course, and it's gone back and forth ever since then. So presently, it's a very, I think, pro-labor board. I think very few people would disagree with that characterization. President Obama, it takes a couple of years typically for the new administration's selections to all fill the vacant seats because they're staggered. And in this particular administration, there's been a lot of controversy and a lot of litigation and problems with keeping the board fully intact. But we have a full board now. Brief history, it's relevant to our conversation. Way back in 1934, actually I think it was 35, the National Labor Relations Act was enacted. Back then, of course, we had no minimum wage laws, no child labor laws, no overtime pay, no anti-discrimination statutes, etc. So unions played a big role in securing worker rights, and nobody would deny that, although that was a long time ago. 1954, unionization in the United States peaked at just over 1/3 of the workforce. This is private sector. They dominated various industries, certainly steel, auto, construction, trucking, mining, etc. And not just those industries, but the rate of unionization was high across the board back in the 50s. Today, unionization is way down. 6.7% is the latest figure from the Bureau of Labor Statistics. That means 14 out of every 15 workers in the private sector are non-union. It's a different story in the public sector, which has a unionization rate of almost 50%. That's been a reverse trend. Back in the 50s, that was like 5%, so it's almost exactly the opposite. There are reasons for that, which I won't get into. The National Labor Relations Act does not cover public sector employees. Union organizing process, again, very briefly. That typically starts with employees who are upset for one reason or another, contacting a union organizer, whether it's a pay issue, a benefit issue, or a fairness issue in the workplace or something else. They're upset with their employer. They reach out for assistance. The union organizers are ready for those phone calls, more than eager. They will quickly recruit and train a group of internal employee organizers, members of the business's workforce, who are become the eyes and ears of the union inside the workplace. And the reason for that is because the union does not have access to your private property, does not have direct access to your employees, except if they're willing to come to a meeting outside of work, which some do and some don't. But the internal union organizers, the internal pro-employee organizing committee members have a lot of access to the employees. The union quickly identifies a target group, an appropriate bargaining unit. The rules have changed, which I'll mention briefly toward the end here, how that has happened. But the rules have changed so that it's much easier now for unions to create bargaining units to their own liking. In the past, there were certain parameters that the unions had to conform to. That's a lot less true now than it used to be. Once they've identified the target group, they are required, in order to file a petition with the NLRB for an election, to make a showing of interest. A minimum of showing of interest means that the union needs to gather signatures from at least 30% of the employees in the target group or in the bargaining unit. And they need to file those signature cards. They're typically post-sized card documents, employee signature and date. They have to be a fresh representation of employee sentiments. The board has held that that generally means that they have to be within a year or so. The signatures can't be 2 years old, but can be up to a year old. Those, once it has 30%, it has the right to file a petition, and the NLRB will conduct an election. Most unions, however, will not file with only 30% or 40%. A lot of them won't file with less than 60%. The reason for that is because they need a majority to win the election and to become the bargaining representative, and it's a waste of their time and resources if they don't have a good prospect of winning the election. They also know that when employers become aware that a petition has been filed, hopefully you've become aware of organizing activity before that, but certainly by the time the petition's filed, then every employer is notified. So if you didn't know beforehand, you know then. And typically there's a counter campaign from the employer, meeting with your employees and educating them about the downsides of unionization. And as a result of the management campaign, typically the union support falls off, and the union wants a cushion to still be able to win that election if possible. Once they have enough cards, what they consider to be enough cards, they file the petition, and the union is always eager for the quickest possible election once that petition is filed. Why quick elections favor unions? That's really what this webinar is all about, and that's what these new rules are all about. It's all about making the elections happen in a much quicker manner than they have been happening historically. First of all, the timing of the petition is dictated by the union. They could be organizing for up to a year, as I mentioned, or for months. In most cases, it's not that long, but it could be months. It's usually at least several weeks. And during that time frame, they are giving a one-sided sales pitch to the employees. There's usually no formal, even if management knows, you usually don't run an aggressive counter campaign because you're hoping the union won't build enough strength to file a petition. So the union has the momentum in the early going. And even when they have the cards, though, if they have, let's say they wanted 60% of the cards and they have that, they're not obligated to file the day they hit 60% or the next day or the next week. They can file when they want to. They can be strategic about it. So they might look at the calendar, for example, and try to time the election, near the end of a holiday period, or just before, or during, if you're a seasonal workforce, during an off season, or whatever is happening within your organization. May be relevant to their strategy on when to time the election. But ultimately, once they file, then the NLRB procedural clock starts, and that's not controlled by the employer. It's controlled by the union. The other point, which I sort of made already, but it's important to emphasize that the union strength in most of these cases, almost all of these cases, is at its peak on the day it files its petition. Because again, even if the employer knew, sometimes the employers don't know, but even if they did, they haven't begun in most cases to run an aggressive campaign because they're saving that for the period leading up to the vote if a petition does get filed in many instances. And so the union has, again, been giving a one-sided sales pitch, and there's the employees who are in favor of it, if they've gotten over 50% to sign, believe that the decision's already been made, and that a majority wants this, and the majority is going to be voting for it. The union likes to make people think, and many employees do, I think, believe this, that once they sign a card, that's tantamount to voting, which it's not. But signing a card and voting are like two different things. Are two different things. You could, an analogy could be that you register to vote, or you vote in a primary if you're a party member, and then you have the general election. That's where the real vote gets cast. And so until there's an election, there's no real vote. But nevertheless, the union likes to portray the situation as though a majority has already decided. Psychology of the messaging, I've already sort of started talking about that to some extent. But first of all, unions are selling what every employee wants, including, the employee at the lowest level of an organization all the way up to the top, which is we all want higher pay if we can get it. We all want better benefits if we can get them. We all want more time off, et cetera, et cetera. So everybody wants what a union is selling. I think the best analogy in today's world, we used to refer to it as snake oil, which was the 100-year-old version of the cure-all medicine, but it didn't do anything. Today's best analogy, I think, is the diet pill, the magic pill that you take to lose weight. You see it on TV all day long and all night long, but do they ever work? A union is selling things that it really can't deliver. Nevertheless, people are interested. People are interested because they hope for greater pay. They hope for more job security. They're interested because they're afraid of, being arbitrarily discharged by management, which the union, promotes that way of thinking. And for all these reasons, the union is playing on emotions, and it's creating adrenaline and getting people excited. And also, the union likes to capitalize on bandwagon psychology, meaning once they start to get a lot of numbers, and especially if they get 50 or 60% of the cards signed, they like to make people think that this is a done deal, you better get on board so you won't be left behind, et cetera. So the psychology of the messaging is very much in favor of the union in the early going. What the employer has to counter that with is practical reality. And practical reality is not, a sexy topic, so to speak. It is not. It's not about emotion and excitement and adrenaline or hopes and fears. It's more about logic and reason and being realistic and what really happens in collective bargaining, what really happens once a union gets elected, et cetera. So that message is. It takes longer for it to sink in, and that's why quick elections. That's one of the big reasons why quick elections favor unions. Okay, more on this. Employers are often taken by surprise. Again, I mentioned sometimes you know it's coming, sometimes you don't. But you're always starting from behind, because even if you found out before a petition got filed that there was organizing activity, you will not have found out at the very beginning of the union's campaign that a campaign is happening. And the earlier you find out, the better. But inevitably, you're starting from behind. The union is out there selling its message. The first thing that the employer needs to do is train and educate all your managers and supervisors. That's absolutely essential. That happen immediately as soon as you first become aware, if you haven't done it on a preemptive, proactive basis. And the reason is because there are restrictions on what managers and supervisors can say and not say, what they can do and not do. And if they don't know those rules, they're going to likely be committing violations, which is going to make it easier for the union to win the election, as well as to raise legal challenges even if they lose the election. So that has to happen. The employer needs to gather intelligence and identify the employee issues. What were the reasons why employees became interested in unionization? What are they unhappy about? It starts with, like I said, typically a group of disgruntled employees who are unhappy about something, but then it also builds from there with the promise of, with the union organizers promising better pay and benefits and other things. And so we need to figure out, one thing is why were folks unhappy, and then the other thing is what are the union's selling points, and how are people reacting to those, and which ones are resonating and which ones are not. We need to analyze the bargaining unit. Does the petition identify a bargaining unit that's appropriate under NLRB principles? What's the composition of your workforce look like? Are there any nearby facilities that should be included potentially, other job classifications, other departments, et cetera? You need to develop a communication plan for the time between the day you become aware of this or the day the petition gets filed and the day of the election, which takes a lot of thought, a lot of effort, and a lot of work, and so that's a big activity that you're going to have to undertake. And then, obviously, you need to keep running the operation, maintaining productivity, managing logistical issues, because in any management campaign, you have to include meetings with employees. There's a lot of conversations, a lot of talk in the workplace that relates to the union issue, which is a huge distraction from normal operations, but so somehow you have to do both, and you have to absolutely make the campaign a top priority. So for all these reasons, the employer needs time. The employer needs time to understand what the issues are, understand what's happening, and to develop a strategy. And if we have an election very rapidly, that becomes maybe more than difficult. It can become almost impossible. Well, under current procedure, one of the biggest decisions that an employer has to make as soon as a petition gets filed is whether or not to stipulate. What that means is there's two ways to have an election. One is by way of a stipulated election agreement. That means the NLRB board agent who's assigned to your case will solicit the employer's representative and the union's representative to ascertain what their positions are as to the bargaining unit, and also what their positions are with respect to the time for an election, the date for an election. And if the two parties can agree and it conforms to the board's guidelines, then they will all sign off on a stipulated election agreement, and the election will be conducted according to that agreement. In the absence of an agreement, then there is a hearing, a representation hearing, where the employer has the opportunity to raise challenges to the composition of the union's petition for a bargaining unit, argue that it's leaving out, typically you're arguing that it's leaving out folks who should be able to vote, or it's simply an inappropriate unit because of the way it's constructed. The hearing is primarily for that reason, to deal with bargaining unit composition issues. However, the effect of the hearing is that it delays the election in most cases under current procedure. Whether you're going to a hearing because you have genuine issues about changing the composition of the bargaining unit, or whether you're going to buy time, either way, it's a critical tactical decision. And a lot of elections, frankly, in my experience, turn on this, can turn on that, and do turn on that decision. How you play the hearing issue versus the stipulation issue. Naturally, the composition of your voting group is very important. Everyone likes to criticize gerrymandering in the political arena, redistricting, but it's been a fact of life in this country for 250 years almost, and that's true here as well, that the union's looking for the group that it believes it has the best chance to win in, and management likewise would like to have the group that it believes it has the best chance to win in. Okay, pros and cons between either doing a stipulation or going to a hearing. With a stipulation, the voting group is fixed at an early stage, so you know who you're dealing with. You know who your audience is. The timing of the election is set, so you know what your target date is. You may be able to negotiate. This is a key point that, in my experience, that a lot of folks aren't talking about in terms of what the effects of these new rules are. But a key point for me has always been using the threat of a hearing to negotiate a favorable stipulation. In other words, the union says we want to organize these 6 job classifications, which might add up to 45 people, let's say. And we say, well, there's 3 other job classifications that we think should be included, which would add another 10, which can easily make the difference in an election. A lot of these elections come down to a close vote. So our argument is we think you should add those 3 job classifications, and if we can't resolve that issue, we're going to go to a hearing. And the union always wants a quick election, so the last thing they want is a hearing. Sometimes they'll give you 1 or 2 of the job classifications. They may even give you all 3 because they've made a calculation that they think they can win if we have a quick election, even with those additions to the voting group. Also, you can negotiate over the timing of the election, and so there is that potential when you stipulate to get a favorable deal, which would which would be help you win the election. The disadvantages are it gives the union largely, because unions won't agree to anything radically different than what they originally sought, so they largely get the voting group that they desired. Also, they get the quicker election. So those are the pros and cons of a stipulation. A hearing, if you can expand the bargaining unit, in almost all cases, management will try to expand the bargaining unit if it can. And the reason is very simple. The union has identified a bargaining unit that it believes, based on all of its legwork, that it can win an election among these, let's say 50, for example, 50 voters. It thinks it can win that election. If the employer can expand that out to 70 or 80 voters or any bigger number, you're adding employees who the union has made a decision. They don't think that they have a majority support within those groups. So even though you would never, if you added 20 positions, let's say, or 20 voters, you probably wouldn't get all 20 of those to vote against the union, but you'd probably get more than half of those to vote against the union, or the union would have included them in their petition. Sometimes you can do fairly big expansions depending on the composition of your workforce, whether you have nearby facilities, et cetera. So that diluting of the union's strength is a big advantage to going to a hearing if you think you can litigate that issue and prevail on that issue. Now that's a whole other, whether you can win at a hearing is a whole other discussion. The other advantage, though, is that just by going to a hearing, as I mentioned, you're going to typically delay the election. There's a couple disadvantages to going to a hearing. One is that you don't know for sure who the voting group is going to be until much later in the process, because you have to wait a decision after the issues have been litigated in the hearing to find out who the regional director decides will vote in the election. You also, of course, are spending time and money and resources on the hearing process, which is a distraction from the campaign process. You can do both, but it's hard to do both very effectively. So you have to devote most of your attention to that hearing process until you get through that. So there are some disadvantages to a hearing as well. What's very important ultimately is the timing of the election, and the existing procedures are very specific. Day one is the day the petition is filed. If you stipulate, then you have to have your election according to board guidelines, long-standing board guidelines, within 42 days of the date the petition was filed. So, for example, petition gets filed January 1st, election has to be held by February 12th. Again, you have the certainty of knowing the date because you'll agree to it in the stip. You have the certainty of knowing the voting group, but you're going to have that election within less than 6 weeks. If you go to a hearing, current procedure is day one is the date the petition is filed. Day 10 is the date the hearing is scheduled by the board automatically in case you need it. If you stipulate the hearing is canceled, but they always schedule it up front. You can request an adjournment up until the 14th day, which we almost always do. So day 14 becomes your hearing day. Most hearings are completed in one day. Depending on the complexity of your workforce and the size of the election, you might need a multi-day hearing, but in most cases it's a one-day hearing. So the hearing would be held on the 14th day. You then have 7 days to file briefs under current procedure, so that means you're now at day 21. Then once you file your briefs, your post-hearing briefs, you wait for the regional director to issue a decision. We don't know when that decision will issue. It could be the day you file your briefs. That would be the earliest. It could be a month after you file your briefs. It's usually 2 to 3 weeks. Depending on the complexity of the issues, you know, it goes longer. Depending if there are simple issues, it can go quicker. But it also depends on the board's own caseload, how busy the office is at the time, et cetera, holidays, all that stuff can have an impact on when that decision issues. So also, of course, the issues themselves, the legal principles that are being argued by both sides, depending on how significant those issues are, you know, it may take longer for the board to write its decision. Once that decision is issued, whether it's 1, 2, 3 weeks after the hearing, after the briefs are filed, then there's an automatic 25-day waiting period because currently either party can file an appeal from the regional director's decision. So if the employer doesn't get what it wanted or doesn't get all of what it wanted, it can appeal, and if the union doesn't like what was decided, it can appeal, and an appeal to Washington from the regional director's decision. And that process takes up to 21 days. So the board has a guideline now that they won't schedule the election until between the 25th and 30th day from the day of the decision. So again, back to our example, petition filed January 1st. Now we might have an election if we go to a hearing in the first or second week in March. So you've gained a significant amount of time for your campaign, which for all the reasons I mentioned earlier, both psychologically and in terms of how you manage the process, time is a huge ally for management. Okay, the long-standing problem, back to the history here, the rate of unionization in the United States is way, way down. It's been a steady downward track. There's been no real change from that trend for many decades. The solution from organized labor's perspective, or the way to get that rate back up, the original idea was the Employee Free Choice Act, which everybody probably listening to this has heard of. It was the legislative fix that was proposed during the campaign prior to President Obama's first term in office, and that was on his legislative agenda to do once he became president. It was derailed in Washington. Ultimately, the House of Representatives switched to the Republican majority, and the legislative changes never became possible for organized labor. But what this administration has often done is when it can't accomplish something legislatively, it switches to administrative action or executive action, which is what this is. The NLRB's new rules are the agency voting internally to change the way it does business. Okay, a little bit more brief history here. I think it's interesting. The Quickie election rule, it's sometimes known as the Quickie election or the ambush election rule, was first proposed 3.5 years ago. There was a public comment. Shortly thereafter, a federal court blocked the new rules because those of you who follow NLRB will remember that there was quorum. It was not valid. And of course, fast forward to today, the board subsequent deals in Washington have resulted in all 5 members, all 5 seats on the board being occupied by nominees who were confirmed by the Senate. Back in, let's see, and so on December, last week, on December 12th, the board, I was going to say back when I did this webinar back in February, we were reacting to the fact that the board had reissued its proposed rule. And what it did was not only did it basically disregard the fact that the prior rule had been blocked by a federal court due to the lack of quorum, but also it disregarded the fact that it had modified its position on several issues and went back to the original, more radical version that was initially proposed 3.5 years ago. That happened earlier this year, but the board hadn't voted on it yet. Now, last week, the board voted on it, and naturally, as you would expect, it was a 3-2 split decision. The Democratic appointees voted in favor of the rule. The Republican appointees voted against it. And but nevertheless, it's a fully constituted board. They have decided to adopt the rules. They have decided the rules will become effective on April 14th, 2015 for the quicker elections. We do anticipate there will still be legal challenges to this, but the likelihood that those challenges will be successful, I think, is not at all likely. The quorum issue was a sort of a procedural defect that created an opportunity to undermine what the majority wanted to do. But now that the majority of the board, which is properly constituted, has made this decision, and you're probably going to have to, it's unlikely to me at least that the courts will be able to change this, and so this will be the law of the land unless and until there are new members of the board and the political winds have shifted to overturn. So what do the new rules do? The reason, by the way, it took so long to get to this part of the presentation is because I think in order to understand the impact of the new rules, you really need to understand the process, the way it's been done up to now, what the relevant factors are. So the new rule does this. It says, number one, you can file your petitions electronically, and that the petitions will be served on the employer electronically. That shortens the clock by 1 to 2 days. That doesn't seem that significant. Maybe every day counts, I will tell you, but that's just the first thing. Next, hearings are to be held within 8 days instead of 14 days. So now you're taking 6 days off the clock. Also, there are new obligations that an employer has to submit a pre-hearing position statement where you lay out all the issues. You're not obligated to do that now. It's kind of like discovery and litigation. And you were not required to turn over very much information at all before you show up for the hearing. Under the existing rules, under the new rules, you have to provide detailed information. Once the hearing is held, there's no more post-hearing brief. You have to close the hearing with your oral argument. There's 7 days off the clock. That is a big change. It is not only days off the clock, but also I think significantly disadvantages an employer to not be able to make a high-quality argument based on existing case law precedent and the facts as they're developed at the hearing in a post-hearing brief. I guess the biggest thing in my mind is that hearings are eliminated for any voter eligibility issues involving less than 20% of the proposed unit, which is a pretty big threshold. If you have 100 people voting, you're going to have more than 20 in controversy to be able to have a hearing, and that's not usually the case. Often these hearings are about, it could be about 5%, 10%, 15%. And under the new rules, you won't be able to have a hearing if there are only that many people in controversy. The new rules also eliminate pre-election appeals of regional director rulings. I talked about the 25 to 30-day period after a decision is issued post-hearing before an election can be held. That is being eliminated. That shortens the clock up to 14 days. The employer, for those of you who have done this or know about it, there's a thing called the Excelsior List where the employer has to disclose all the names and home addresses of the members of the bargaining unit, and that gets turned over to the union. That's now due 7 days after the stipulation or after the decision following a hearing. Under the new rules, it's due in 2 days. Furthermore, it is not limited to names and home addresses. Under the guise of modernization, it now must include employee email addresses and additional information. So there's 5 days off the clock. So now you begin to see that it's a huge shortening of the process. Essentially, in my opinion at least, and we're all going to have to see how this really plays out once these new rules become effective, but it appears to me as though effectively you're going to lose your right to a hearing in most cases, which means a key tactical tool will no longer be available for the employer. It also means you won't have the leverage that you used to have to be able to negotiate a favorable stipulation. So basically, the union's going to be able to pick who it wants to organize without much opportunity for challenge. And the election's going to be held quite quickly, so the employer has not much of an opportunity to counter their messaging. And the employees who are generally, not completely informed on this subject and who are interested in the points that the union is selling, which are things that everybody wants, universally desired outcomes, they're going to be much more vulnerable to making a poor decision or making an uninformed decision. The 42-day clock, there are different estimates now, and again, we'll have to see how these new rules play out. I think it'll effectively cut this clock in half, probably to more like 21 days. Some have said it could be as low as 10 to 12 days from date of petition to date of election. That, if any of you have been through a campaign, if you have an election 10 days after petition is filed, that is an almost impossible challenge to overcome. I'm not saying, and I would never say that you can't win that election, but it makes it much, much more likely that the union will prevail. There are some other developments, and there's all kinds of developments, which I'm sure you all read about all the time from this NLRB, but there are some other, in my mind, extremely significant developments that are worth mentioning. Specialty healthcare was a decision from 2011 by this NLRB, which reversed 20 years of precedent and now allows unions to form highly selective micro units. In the past, there were guidelines, established rules and precedent about how bargaining units are formed. So, for example, in a manufacturing setting, it might be all production and maintenance employees was a well-recognized bargaining unit. In healthcare, it would be in a nursing home, all non-professional employees, for example. Under specialty healthcare now, the board has said the union can organize subgroups. Instead of all production employees, it might just organize assemblers. Or instead of all non-professional employees in a nursing home, it might organize just the CNAs. That gives the union the opportunity to cherry-pick the workforce way more than it used to. And the employer, under this new guideline, your only basis for challenging that is to prove that there's an overwhelming community of interest between the employees who the union excluded and the ones who you think should be included, or the ones who historically would have been included. which is a very high standard. It's like beyond a reasonable doubt in criminal court. It's hard to ever prove that. Furthermore, now you're not going to have much of an opportunity to prove that because you're going to have either a shortened hearing and no brief or no hearing. Just last week, along with the day before, we got these new Quickie election rules. The board came out with a decision called Purple Communications, overturning registered guard, for those of you who know case names. Basically what that says is employees can now use the employer's email system for organizing purposes during non-work time, theoretically, but presumptively they can use your email system, whereas under registered guard, presumptively they could not because it's the employer's property. So when you add the combined effect of these things together, and I think the Purple Communications is significant, but much bigger case was specialty healthcare in my mind. The union has the ability to cherry pick the workforce and to force a quick election. So I think unionization will clearly be on the upswing if these rules take effect, which I think they will, and over the course of time, I think that 6.7% private sector unionization rate is going to start moving in a different direction. Okay, ambush survival plan. What can you do? First of all, a lot of organizations will have proactive supervisory training even when there's no known organizing activity, so that your managers and supervisors know the rules every year, every 2 years, but a lot of organizations don't do that. Our advice is that that if you're a union-free or only a partially unionized organization, that you cannot afford to forego regular supervisory training. Teaching them about the organizing process, what to look out for, what the early warning signs are, what the rules are so that we don't make mistakes and create legal leverage for the union, et cetera. Another thing that you should do, if you haven't already, is you should look at your own workforce and figure out what the potential bargaining units are. There are oftentimes quasi-supervisory issues, people who have a leadership role of some kind but may not qualify under the law as a supervisor within the meaning of the National Labor Relations Act. You can evaluate what the potential units are, what the potential supervisory issues are, and you can make adjustments potentially to improve your chances in the event a union comes calling. The biggest thing is to just closely, more than ever, and hopefully you're doing this anyway, but more closely monitor your employee satisfaction. Some like surveys. It doesn't have to be by way of a formal survey, but I think you should at least have an employee relations committee, which doesn't, and I'm not talking about employees on the committee, I'm talking about HR folks and department leaders, or depending on how you're structured, plant managers, et cetera, people who come together on a regular basis to talk about employee issues. Are there things that people are upset about, how's morale, et cetera, and to then try to resolve those issues to the best of your ability, or at least communicate with respect to those. Soliciting grievances refers to finding out with employees, meeting with employees as well to find out from them what their concerns are and to try to address those concerns. There are certain union policies, probably related policies in your handbook, that need review. It's amazing how often we still find mistakes in your no solicitation policy. You should all have a no loitering policy. If you don't, a lot of places don't. Most places probably don't. That says that if you're not scheduled to be at work, you shouldn't be hanging around the workplace, basically. A lot of employers will be considering, and I think it's wise, adopting a policy that specifically talks about the company's view or the organization's view toward labor unions. We're not anti-union, we're pro-employee. We think employees are better off if we maintain a direct relationship. We think teamwork works better than conflict, some kind of policy statement that says those things. Beyond all that, it would be wise to come up with a game plan, a ready-made game plan with some ready-made communications, especially a card signing letter that can be drafted. You could always tweak it, of course. A 21-day game plan for a campaign. Run a campaign fire drill, which would involve meetings with key management personnel as though we had been served with a petition, what needs to happen so that they understand and they're all ready if and when the time comes.